Well, good morning. Thank you very much indeed to Elwyn for her very kind, gracious introduction. Thanks to Stuart and Amy Louise in particular for all of the organisation that's gone into this conference. And may I say how much I enjoyed being with you for most, I couldn't manage all, but most of yesterday. Forgive me for singling out just 3 names. It's always a pleasure to share time with Paul Gill from UCL and to hear what he has to say about risk online and offline and those with fixations and how to deal with it and how to address it. For the first time, I heard Gareth Mott yesterday on blockchains, peer-to-peer social networks, and in particular the recent perhaps not phenomenon, but the appearance of Twister and its potential replication. And then thirdly, I was taken by a presentation from your very own Joe Whittaker from this university on online radicalisation, which I thought fascinating, which prompts or should prompt longer discussion. And I'm sure that in our various breakout groups over coffee, we will have those discussions. This speech will be available in full, should anyone want to read it again. You don't have to. I'll probably put it on my own website, as I do with all public speeches. I'm conscious that I'm one of the very few practicing lawyers today amongst so many academic lawyers and technical specialists. So with apologies to the latter, but in the hope that it is interesting, I am going to take us back to some of the fundamental legal principles in play, because that's what I do, and I suggest we all need to be mindful of them. There can be no doubt, can there, that social media plays a pivotal role in communication between those intent on terrorism, just as it is pivotal in the daily lives of most of us as we go about our lawful business. And in that simple truth lies the dilemma which we all face at this conference. We all deplore the outbreaks of terrorist violence that we have witnessed in 4 vicious attacks since March the 22nd this year, the most recent of the 4 perhaps emanating from Wales, though there is little more that we can say now that that case has been charged and is before the courts. But we have been reminded already this morning, and it is important to remember, that 5 terrorist plots were successfully disrupted by the police and security services during that same period, the last 3 months. And we all come together with renewed determination to face down the menace of modern terrorism. Where these awful crimes are facilitated by the use of social media, we want to close down the criminals' ability to communicate. And yet, we must recognize that policing the internet and controlling social media comes at a very high price if it interferes with the freedom of communication which every citizen enjoys, and which is also enshrined in Article 10 of the European Convention on Human Rights. But let us go straight to the limiting provision within Article 10, remembering, of course, that freedom of expression is not a fundamental right. And for that reason, Article 10, paragraph 2 reads, "The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and as are necessary in a democratic society in the interests of national security, territorial integrity, or public safety for the prevention of disorder or crime," etc., etc. It goes on, we needn't read the whole thing. So have we reached the point at which we need to legislate for further interference with Article 10? Well, before we can answer that question, we should remember that statute already interferes with Article 10 where necessary and proportionate. Consider Section 2 of the Terrorism Act 2006, the criminal offence of disseminating terrorist publications. Many questions. First one, what is a terrorist publication? Well, it's defined within Section 2, subsection 3, may I read, if matter contained in the publication is likely, A, to be understood as a direct or indirect encouragement or other inducement to the commission, preparation or instigation of acts of terrorism, we normally shorten that to CPI, or B, to be so useful and to be understood by some or all as wholly or mainly for the purpose of being so useful. It's a mouthful, but that is the legal definition of a terrorist publication. And against that background, a person commits the offence under Section 2.2 by distributing or circulating such a publication, which includes, of relevance to us today, Section 2.2e, transmitting the contents electronically, within the statutory definition, and where he or she, and this is Section 2.1, B and C, intends an effect of the conduct to be a direct or indirect encouragement for CPI, or when he intends to provide assistance in CPI. It's actually quite a broad definition. So that's the definition. The Section 2 dissemination offence works in practice. One of the significant decided cases in this area, which I happen to have prosecuted myself, was Faraz, F-A-R-A-Z, tried at Kingston Crown Court in 2011 and reviewed on appeal. I'll give you the citation, 2013, 1 Criminal Appeal Reports 29. 2013, 1 Criminal Appeal Reports 29. My friend and colleague, Professor Bruce Hoffman, was an expert witness in that case, and it's been excellent to catch up with him and gather from his expertise at this conference. At that trial, Section 2, and bear in mind we're considering Article 10 of the ECHR here, Section 2 was read down for compatibility with Article 10 in a number of ways. For example, by requiring that the words acts of terrorism in Section 2 must mean criminal offences. Any lesser form of conduct, not enough. Must mean criminal offences. There were a number of further revisions or reading down made by Mr. Justice Calvert-Smith after submissions, I can tell you, which had considered a comparative analysis from many legal jurisdictions. The Court of Appeal later held that it was not arguable that a publication that to the knowledge of the defendant carried a real risk that it would be understood by a significant number of readers as encouraging terrorist offences was entitled to exemption because of Article 10, just because it expressed political or religious views. So we have the offence with the requisite reading down for compatibility. The Article 10 defence goes, doesn't run. That is part of the robustness of the statutory framework that we have. And therefore, through laws already on the statute book, it is both possible and compatible with the ECHR for investigators and prosecutors to reach into social media and the internet for material which can properly be brought before the court. The question for us is how much further, if at all, should legislation go into this arena? Well, how to do this? A quick review of the social media imprint within recent criminal prosecutions might be helpful. So I therefore looked through all of the successful terrorism prosecutions brought by the Crown Prosecution Service last year, 2016. Allow me to discuss the relevant aspects of some of those cases now, because they may indicate how prosecutors are currently dealing with social media as evidence, and they set the context for any consideration of where we go from here. So a sentence or two on some, not all, but some of the cases from last year. Tariq Hassan and Suhaib Majid, the latter a physics undergraduate at King's College London, used a variety of secure and encrypted systems to communicate with each other. Hassan was studying in Khartoum at the time, and they communicated concerning their plot to carry out terrorist murders in London using a silenced firearm. The evidence at trial included online reconnaissance of a police station and territorial army barracks. They were charged with conspiracy to murder and preparation of terrorist acts under Section 5 of the Terrorism Act 2006. Note, one common law offence, one Terrorism Act offence. I'll expand on that in a minute or two. Tarina Shakil, aged 26 and the mother of an 18-month-old son, became prolific on social media in support of Daesh. Her messages included an exhortation, I quote her, to take to arms and not the keyboard. She took her son to Turkey and on to Raqqa in Syria, joining Daesh and using the internet both to maintain contact with other family members and to glorify Daesh. She was charged with encouraging terrorism under Section 1 of the Terrorism Act 2006 and belonging to a prescribed organisation, namely ISIS, under Section 11 of the Terrorism Act 2000. Note the breadth, the growing list of statutory provisions being used. Next case, Ayman Shaukat engaged in coded communications with men whom he assisted in travelling to Syria. Shaukat drove a co-defendant, his name was Alex Nash, to the airport and facilitated his desire to join ISIL. Charged with preparation, Section 5, 2006 Act. Forhad Rahman assisted a man called Asil Mutana to leave the UK in order to fight in Syria, and the two men first met via social media. Mutana and another made a video on a hill near Cardiff, not so far away, in possession of an imitation firearm, referring rather chillingly to the Islamic State in Cardiff and Iraq and Sham. Their co-defendant, Kaleem ul-Haq, used social media to send money to another whom he believed to be fighting in Syria. Charged with preparation, Section 5, 2006 Act, and in respect of the funding arrangement, charged under Section 17 of the 2000 Terrorism Act. Junaid and Shazib Khan, whom I also prosecuted, were inspired and instructed online. Firstly, on how to get into so-called Islamic State, and secondly, in the case of Junaid Khan, how to access the addresses of soldiers in the United Kingdom and how to attack USAF bases in Norfolk. Online kick conversations spoke of aspirations to seek shahada or martyrdom, together with explicit instructions for mujahid-style knife and or pipe bomb attacks. Both men charged with Section 5 of the 2006 Act preparation, Junaid Khan receiving a life sentence, albeit that was slightly modified on appeal to 20 years with an extension to his license. Zafreen Kadam was investigated after complaints made to the police that a Twitter account was being used as a tool to post so-called IS propaganda and to encourage others to join so-called IS and to instigate acts of violence. This defendant was found to have opened 14 Twitter accounts in 1 month in the spring of 2015. Extreme content was posted, including a web-based IS document encouraging the online dissemination of IS literature in order to support its cause. The document was viewed 1,464 times before it was captured by the police as evidence. In addition, this defendant used WhatsApp to send material including execution videos. He was charged with 10 counts of Section 2, 2006 Act dissemination. Mohammed Alam used Paltalk Messenger to send links to an ISIS video, and he was charged with Section 2 dissemination on the basis that he was reckless as to whether it would encourage CPI, terrorism. Note the lower mental state, the lower mens rea that was involved and sufficient in prosecuting that case. And Mohammed Amin sent 8,000 tweets over 7 months using 16 different Twitter accounts and 42 different names expressing support for Daesh. He was charged with that encouragement offence, Section 1, 2006 Act, 1 count of Section 2 dissemination, and 1 of inviting support for a prescribed organisation under Section 12 of the 2000 Act, another offence we haven't mentioned so far this morning. The judge, in passing sentence, and it was 5 years imprisonment, noted that the offending was aggravated by the explicit and intentional nature of the encouragement and by the persistence with which it was pursued. A few more examples. Nazir Taj used Twitter and WhatsApp seeking advice on where to go in Syria to satisfy his aim to become a suicide bomber, charged with Section 5 preparation, possession of material under Section 58 of the 2000 Act, and an offence under Section 4 of the Identity Documents Act 2010. You may want to remember that. Rebecca Poole used social media to express her desire to marry a jihadi warrior and to travel to Syria to live under ISIS and to become a suicide bomber. She was later found unfit to plead, but to have been in possession of material under Section 58 and sentenced to a restricted hospital order. And mental health disposals, I'm not going to say a lot more about it now, but it seems to me that too plays an important part. We might discuss that later. Mohammed Uddin travelled to Syria via Turkey, stayed for 5 weeks, and then left under pressure to return to his wife here in the UK, but expressing his disappointment with the slowness of progress in Syrian training camps. And his social media messaging indicated an intention to return to Syria in the future. Charged, Section 5, preparation. Mr. and Mrs. Golamully pleaded guilty to terrorist funding under Section 15 of the 2000 Act, having sent money to their nephew who had travelled from Mauritius to Syria to fight for ISIS. They used WhatsApp messaging and they sent money via Western Union. Abdul Hamid both received and posted Daesh propaganda using his Facebook page. A police investigation revealed that a redacted version of the video he posted was available via the BBC and other media outlets, but the defendant had repeatedly posted the unredacted full version. That's where the offence lay. And latterly he did that with a message reading, "This video is strictly for education purposes only." Well, that may have been his message, but he was charged and convicted under Section 2, dissemination. And finally, Aras Hamid, Shivan Zangana, and Ahmed Ismail were variously charged with Section 5 preparation, identity document offences under the 2010 Act, I mentioned that earlier, and failing to disclose information about acts of terrorism under Section 38B(1)(b) of the 2000 Act. An interesting offence, perhaps for a longer discussion later. These individuals used phone and social media contact to discuss and arrange travel to join ISIS, discussing the planned travel with a facilitator abroad. So that's the range and the frequency of offending, which sets the context for our discussion. And that is last year, of course. We are yet to come to grips with a full review of the atrocities of 2017. I've left out, for present purposes, an analysis of sentences passed in these cases, because that's beyond the confines of this conference, although I predict that the available maximum sentences for several of the main statutory offences will feature in the ongoing government review of counter-extremism strategy, and some sentencing powers may rise. That said, it does not follow that the review will necessarily lead to the identification of new offences not currently on the statute book. Perhaps that's a discussion for another day, another conference, particularly the sentencing regime. Returning, though, specifically to social media and its prevalence in current terrorism offending, it's clear how important this continues to be to investigators and commentators alike. In some of the cases that I've analysed briefly, it's quite possible to observe single days of online communication between defendants and complicit third parties, where those communications range between WhatsApp, Twitter, Telegram, Viber, Kik, and more, according to the perception of the participants as to the relative security and encryption levels of these various modern platforms. So to catch them at it, we have to keep up with their technical knowledge and the march of progress made by the internet and other communication service providers. So where do we go next? It seems to me, thinking about the range of statutes in use by prosecutors, as shown by recent cases, that we actually do not lack for legal powers to bring these cases to court. We do need to encourage investigators and prosecutors to use the full range of current powers at their disposal, which is not, of course, to say that they are ignorant of what Parliament has provided, but we do need to see the use of financial, identification, fraud, firearms, public order, offences against the person, and conspiracy offences being added to indictments in order to capture the full range of criminality represented by future cases. There should be nowhere safe for terrorists to hide. Terrorism-related cases charged in the year ended December 2006 totaled, I thought you might find the statistic interesting, the use of 56 Terrorism Act offences and 62 non-Terrorism Act offences. In other words, where other criminal statutes were used. Interesting balance. More of that is, I suggest, the way forward. But I'm on record from when I first came into post as independent reviewer in March this year, saying that in general we don't need more terrorism offences. And there may be examples of redundant terrorism offences which time has proved are not as necessary as Parliament thought. Interestingly, training for terrorism, which is captured under Sections 6 and 8 of the 2006 Act, was not charged at all in 2015 or 2016. Inciting terrorism overseas was charged once in the same 2-year period. In fact, possession of articles for terrorist purposes under Section 57 of the 2000 Act was charged once in 2015 and not at all in 2016. So some revision and trimming of the current legislation may yet be possible, and in my view, that would be a good thing. But I cannot say with certainty whether the ongoing government review will throw up an example or two that legislators have not yet covered. Maybe that will emerge, and if so, it will be my job to take a hard look. It would be foolish to discount the possibility of one or more new offences for a new age, though I have to say I am yet to find any. And that brings us to the big question, whether the investigation and prosecution of terrorist use of social media needs specific new laws. Well, I spent time analysing recent past cases as a way of showing how much is already possible utilising the laws we already have. To go further, would we risk unenforceable infringements on ECHR rights? And or would we push the current abundance of evidence proving terrorist activity online to go offline or underground into the dark chambers of Tor, impenetrable places within the dark web from which clear evidence rarely emerges, and where the placement of a robust counter-narrative to terrorism is hard to effect and even harder to gauge. We can all agree this is uncertain territory. Driving material, however offensive, from open availability into underground spaces online would be counterproductive if would-be terrorists could still access it. And once this material goes underground, it is harder for law enforcement to detect and much harder for good people to argue against it, to show how wrong the radical propaganda really is. Last week, I made a speech at an event hosted by the Oxford Media Network. It's on the Independent Reviewer website if you want to read it, in which I said to a large audience, including some of our most distinguished security correspondents, the following. I'll read one paragraph. In my view, we should all spend less time in public, through the media at least, trying to elucidate the dogma behind these terrible events, and should instead spend far more time seeing these criminals for what they clearly were. Criminals, or demons, was the title of the event last week. Evildoers of evil deeds. Because there really is no justification for an individual detonating a bomb inside a concert hall filled with thousands of children and teenagers. We should not waste time in public airing the dogma behind the demonic work of Abedi and his like. Of course, this remains the vital, urgent work of the security services and police, whose job is to unpick the dogma, to unearth the radicalizers in person or online, and to stop the next criminal planning an attack, and the next, and the next. But by publicizing and analyzing the dogma for all to see, you are, I asked security correspondents this, perpetuating the myth that these crimes are for a religious reason, or still worse, that they have a justification. That's end quote from last week. I stand by those words. When criminals kill and are killed in the act, we should not give them the media platform that they may have craved in life but are not entitled to receive in death. And I was amongst many who were very pleased to see leading mosques and British Islamic communities who refused to say funerary prayers for those responsible for the attacks in London and Manchester. But that does not mean to say that we or the media need be silent when we see the vile propaganda with which those who are yet to commit attacks drench social media platforms. There is a place for a strong counter-narrative to be put in place to meet the online radicalization efforts of these criminals. So, to those of you who speak on this subject and who, unlike me, have the technical expertise to support an online counter-narrative, I applaud your thinking and your efforts. To the rest of us, the message is, do not suffer in silence, speak up. Speak up from wherever you are within law-abiding, multicultural British life, and do whatever you can to reject the messages of hate that we see online. As some of the speakers at this conference have said already, the omnipresence of social media provides a great opportunity to meet the evils of terrorism, to take the opportunity to prove them wrong. Doing that is far better, in my view, than spending too much time taking the actions of suicide bombers and telling their story for them. Criminals do not speak for us. We must find our own voice and set the record straight. Now, in my 3 months thus far as independent reviewer, I've made it my business to travel around the country, seeking out Muslim communities in particular, because they have been badly affected by all 4 of the terrorist attacks this year. Affected indirectly, as it were, at Westminster, Manchester and London Bridge, but directly at Finsbury Park Mosque. And so I have been to Finsbury Park Mosque, and I have spent time with the Libyan community at a mosque and elsewhere in Manchester. And I have sat with community representatives from mosque chairmen to youth workers in Leicester and in Bradford. And they all offer real insight into the impact of our terrorism legislation upon their communities and of terrorism upon their communities. And they all say one thing that is the same, which I paraphrase thus: nobody really speaks for us, though many claim to represent us. That's what they're saying, to me at least. The communities that I have visited all detest terrorism. They have powerful counter-narratives to terrorism, and they must be part of the answer, online and offline, in dealing with the extreme propaganda that we are all contemplating today. So it's beyond doubt that social media has played a significant role in the planning and perpetration of terrorist attacks both here and abroad. And my short digest of cases from last year surely makes that point. Beyond the need, and I would say the opportunity for a counter-narrative, should we be taking the chance to control social media and the tech companies who support it? Well, in Germany, we heard recently of the suggestion, I'm not sure whether it's anything more than that heavy financial penalties should be imposed on companies who fail to take down extreme content. Discussions between our Prime Minister and President Macron in France suggest that there is a top-table conversation in which solutions are being sought, there's an element of tough talking, and tech companies are not immune from censure. And we read each week of high-level meetings between COOs and even CEOs of the internet's biggest players meeting with our politicians. Much of this is both necessary and valuable. I firmly believe that tech companies should strain every muscle to stem the flow of extreme material online. And I have sat next to Metropolitan Police specialist officers who spend all day, every day, searching the net to find extreme material, and who then systematically apply hash values and other algorithms to identify each and every posting of that material with a view to writing to every web host requesting the takedown of that material. It's laborious work, and it's important work. There must be ever greater liaison and cooperation between law enforcement and tech companies. But I struggle to see how it would help with this battle if our Parliament were to criminalise tech company bosses who don't do enough. Because how do we measure enough? And what is the appropriate sanction? We do not live in China, do we? Where the internet simply goes dark for millions when government so decides. Our democratic society cannot be treated that way. People have to be regarded as grown-ups, entitled to every freedom provided for in a mature democracy, but working together to reduce the menace and prevalence of terrorism and terrorists, those who would do us all indiscriminate harm. So there is a need to do more, and tech companies must realize, if they do not already, that they have to be part of the solution here. There must be a coming together on a corporate level as well as amongst the wider population. Engagement is the answer. And to my mind, companies who make eye-watering sums of money from our everyday chatter need to be brought firmly on side. They do not need to be forced offside by the application of criminal statutory offences with which to beat them, with the inevitable side product of defeating the freedom which the net and social media platforms has opened up for the enjoyment and better understanding of us all about the world in which we live. So I finish where I started, as a lawyer, not a politician, not a civil servant, and certainly not a regulator of social media, nor, I add, a technocrat who understands the algorithms by which these communications platforms operate, because I don't. That's your speciality. Can we legislate to rid ourselves of online terrorism? Well, my answer is that Parliament has already done so in meaningful ways, including such offences as the dissemination offence under Section 2 of the 2006 Act. We lawyers should look hard into such areas to see whether any amendments might hone these offences, given recent technological advances. We should also look to see whether sentencing provisions in 2017 are apt for our world now, for example, where Parliament drew a line in 2000 and where 17 years is a long time in tech terms. But apart from that, further legislation does not strike me as the answer. Criminalisation, and thereby the alienation of tech companies who are there to serve us and to help us, albeit for colossal financial reward on their part, that cannot be the answer. So no or very little new legislation, as it seems to me. That leaves investigation and prosecution to complete my answer to the title of my talk. Both are vital. Both are working well, as last year's cases show, and I await to see the full picture from this year. From my own long experience of terrorism trials, it is the communications schedule which forms the backbone of almost every new trial. And as you know, where communication used to be by voice calls and SMS messages, now that is augmented by online messaging. Much of it, but not all, from end-to-end encrypted platforms, including, of course, WhatsApp. We need the assistance of tech companies to ensure that the comms schedules, the communication schedules in trials from this year and next year incorporate every such platform used by these criminals. My technical knowledge runs out very quickly at this point. It's many of you listening to you yesterday who have important and creative solutions to offer, and that's why I'm here to learn from you and not the other way around. So I finish, if I may, in the technical arena, which I know least but am willing to learn. I ask whether, for example, quantum computing may be part of the answer. Personally, I first heard the term relatively recently. Could it hold the answer to breaking algorithms? What should we be doing towards the sharing of encryption keys? Can network providers enforce encryption and validation as precursors to content being published? And if these things are technically possible, by whom and when should this power be used? And what are we going to do about Twister and successive problems such as that? The future will be very interesting. Thank you very much.